We would like to start with the University of St. Thomas land acknowledgement. Inspired by Catholic intellectual tradition, we invite you to reflect on these verses of scripture that offer us guidance. From Paul's letter to the Romans, chapter 12, verse 2. Do not conform to the pattern of this world, but be transformed by the renewing of your mind. And from James chapter 2, verse 18. But someone will say, you have faith, and I have works. Show me your faith apart from your works, and I by my works will show you my faith.
The University of St. Thomas occupies the ancestral and current homelands of the Dakota people, Minnesota-Makoche. We also recognize the Ojibwe and Ho-Chunk, whose lands were colonized by the United States and are currently occupied by the state of Minnesota.
We condemn the tools of settler colonialism, including genocide and forced assimilation, undertaken in the name of white supremacy that created structures of injustice and inequity that continue to oppress and marginalize Indigenous and underrepresented peoples.
We work toward the process of decolonizing minds and educating students to be morally responsible leaders. We commit to the work of truth-telling and relationship building as we seek new pathways forward as relatives in the University of St. Thomas community, the Indigenous communities, and those who traverse multiple communities. Thank you.
Thank you, Wendy and Amy. My name is Yahuwah Williams. I am Distinguished University Chair and Founding Director of the Racial Justice Initiative, and it is my pleasure this afternoon to host this panel on legal perspectives on a Chauvin trial, what to expect and what's at stake. I'm joined this afternoon by three distinguished colleagues from the University of St. Thomas Law School. They are Professor Rachel Moran, who is Associate Professor and has been teaching at St. Thomas Law School since 2018. She founded the Criminal and Juvenile Defense Clinic, where she works with law students to provide free representation to children and adults accused of crimes. She also designed and teaches a course called Controversies in Policing. Moran focuses her scholarship on issues pertaining to police accountability, police reform, and public access to information about police misconduct. Before entering academia, Moran spent most of her practice career as a public defender in Chicago, where she represented people accused of serious violent crimes. The 2020 graduating class selected her as the law school's Professor of the Year. Our next guest is Professor Mark Osler. Dr. Osler is the Robert and Marion Short Professor of Law at the University of St. Thomas Law School. He holds the Ruthie Maddox Preaching Chair at First Covenant Church in Minneapolis. His writings on clemency, sentencing, and narcotics policy have appeared in the New York Times, the Washington Post, and the Atlantic, and in law journals at Harvard, Stanford, the University of Chicago, Northwestern, Georgetown, Ohio State, UNC, William & Mary, and Rutgers. A former federal prosecutor, he later won the case of Spears versus United States in the US Supreme Court, with the court ruling that judges could categorically reject the mandatory 100-to-1 ratio between crack and powder cocaine in federal sentencing guidelines. Osler's 2009 book, Jesus on Death Row, critiqued the American death penalty through the lens of Jesus's trial. His second book, Prosecuting Jesus, is a memoir of performing the trial of Jesus in 11 states. In 2020, Osler served as chair of the independent panel which reviewed the case of Myron Burrell, and recommended that Burrell receive a commutation of sentence. Osler is a graduate of the College of William and Mary and Yale Law School. Last but certainly not least, this afternoon, we're pleased to welcome Dr. Rachel Paulus. When she was unanimously confirmed by the United States Senate to serve as US Attorney for the District of Minnesota in 2006, Rachel Paulus became the first Indian American in American history to be nominated by the President and confirmed by the Senate for any federal appointment. She is, in addition to being a distinguished scholar, a frequently sought after commentator. She's provided legal analysis for the Washington Post, USA Today, Fox, Minnesota, ABC, CBS, NBC, NPR, and the St. Paul Pioneer Press, among many other media representatives. She has given keynote addresses at the North American South Asian Bar Association Annual Convention, the North American South Asian Law Students Association Annual Convention, and the National Asian Pacific American Bar Association meeting. She also presented at the Nobel Peace Prize Forum, the American Bar Association Annual Convention, International Business Law Institute, and Jewish Community Relations Council, Yale Law School, and the Harvard Law School, among other institutions. Dr. Paulus received her JD from Yale Law School, where she was a Coker Fellow, editor of the Yale Journal of Law and Feminism, and commencement standard bearer. She graduated summa cum laude with the BA from the University of Minnesota, which she attended on full merit scholarships, where she was the commencement speaker, chair of the student representatives to the Board of Regents, and Phi Beta Kappa. Thank you all for joining us this afternoon. We, of course, are here to talk about the upcoming trial of Officer Chauvin. And I want to begin with you, Mark, Dr. Osler, in particular, because I'm hoping that you'll be able to set the context for us and provide an introduction to this trial. What should people be expecting in terms of what we expect to see in the next few weeks?
Yeah, it's going to be fascinating. When we talk about the trial, we're really talking about two trials because there's 4 officers who have been charged. And what's going to start next week is the trial of Officer Derek Chauvin. The other 3 officers, their trial has been put off until late summer. So right now we're just looking at the one officer, and that'll be significant. I think some of the other experts will have something to say about that. What we're going to see is something pretty unique, and COVID influences the way this is going to play out. The courtroom itself is going to be different. There's going to be a limitation on the number of lawyers. There's only going to be a few media representatives that are allowed in the courtroom. That does change things. I mean, for example, even the fact that while they're being questioned, potential jurors may be wearing a mask. And that, of course, hides clues that we're usually going to be looking for. You know, how does someone look when the defendant walks into the room? When we pick juries, that's something we do. And when people are masked, that's going to be a new challenge. Now, people will be able to watch the hearing or the trial because it's going to be televised. And you can see that the Star Tribune is going to live stream it. In addition, Court TV, which is resuscitated, it was dead for a while, is going to be carrying it as well. And this is kind of interesting. I didn't know this. Court TV actually is over the air in Minneapolis. So if all you've got is a TV and an antenna, you can still watch the trial. Now, one thing I want to mention before I turn it over to the others is that what happened last summer was a profound incident and discussion involving race. And something that's going to be jarring to some is that this trial is not going to be about race. That in criminal law, what the government has to prove is the elements of the crime. The defense is trying to show doubt as to one of those elements. And none of those elements have to do with race. And that means that there's going to be a real disconnect between what goes on inside the fencing around the courthouse, where people will be talking about race, and what goes on inside that perimeter. I wrote about this for CNN, and that'll be coming up later today or tomorrow, probably.
Thank you. Appreciate that. Professor Moran, there's been a lot of conversation about the charges that we can expect in this case, legal wrangling over third-degree murder. Can you break down for us what we can expect with regard to charges, not only with regard to Chauvin, but the other officers who are charged in this case?
I definitely can, and I'll try to make this simple. So Derek Chauvin's trial is scheduled to start on Monday with jury selection, and remarkably, we still are not completely sure what charges he will be facing. There are 2 charges that are definite, and I'll explain those. The third charge, as Dr. Williams mentioned, has been very much up in the air, and I'll try to break down how that has happened. But the 2 charges we know for sure. The most serious charge is second-degree murder. A second-degree murder charge involves a maximum sentence of 40 years in prison. So it's a very serious charge. And there are a couple different ways the state can prove second-degree murder. But in this case, against Derek Chauvin, what the state would have to prove is that he unintentionally killed George Floyd, but he did so while committing a separate felony, which is the felony of assault causing serious bodily harm. So none of the charges require the state to prove that Derek Chauvin meant to kill George Floyd, but this most serious charge does require the state to prove that he knew he was committing an assault causing serious bodily harm, and that death unintentionally happened as a result of that assault. The least serious charge, which is still very significant, is second-degree manslaughter. That charge carries a maximum sentence of 10 years in prison. And the difference in the second-degree manslaughter is really about Derek Chauvin's state of mind. So if the state were, in order to find him guilty or to prove him guilty of second-degree manslaughter, the state has to show that he acted negligently, that he knew that there was a risk of death or serious bodily harm, and he negligently created that unreasonable level of risk. So that's kind of, it sounds like legal jargon because it is, but that's what the state has to prove, is that he was acting negligently. Again, not that he intended to kill, but that he created a risk, basically that he shouldn't have created, of death or serious bodily harm by his actions in kneeling on Mr. Floyd. The third possible charge is where things get really complicated. So back in the very first charge filed against Derek Chauvin, actually, and I can't remember if it was the very end of May or the beginning of June, but when Hennepin County was prosecuting this case alone, they filed a third-degree murder charge. After the Attorney General took over the case, they upped the charge to second-degree murder, but tried to also stick with third-degree murder as an alternative charge. And last fall, the parties had a hearing about these charges. The judge allowed the state to move forward on all but the third-degree murder. And at the time, the trial judge's reasoning was that because of the language of the Minnesota statute, he thought that third-degree murder only applies if you behave recklessly, but you create a risk not just to the person who dies, but to others as well. So third-degree, what we know third-degree murder requires is creating that your behavior is so, the language is eminently dangerous to others, that you exhibited a lack of regard for human life. But that language to others is where things get really confusing. The judge thought that meant that you have to create a risk of harm to multiple people. And in this case, only George Floyd was at risk of harm. So the judge dismissed the third-degree murder charge. And everybody moved forward thinking that that charge wasn't going to be part of the case. But about a month ago, in a different case, also involving a police officer whose name was Muhammad Noor, who was convicted of third-degree murder, the appellate court said the opposite of what the trial judge in Chauvin's case had said. They read that same statute and they said, your behavior only has to be risky as to one person, the person who dies. That's enough for third-degree murder. So once that decision came down, the state suddenly asked to reinstate the third-degree murder charge against Derek Chauvin. There's been a lot of legal wrangling about that. I actually checked about 15 minutes before this session was supposed to start, because we are waiting to hear from the appellate court, which is the court that has authority to tell Judge Cahill in the Chauvin case what to do. We're waiting to hear if the appellate court is going to order Judge Cahill to reinstate the third-degree murder charge. We're also waiting for the Minnesota Supreme Court, the highest court in the state, to interpret more clearly what does this third-degree murder statute mean. But they've said they're not going to do that until this summer. So that they have declined to shed light on the issue for the Chauvin case, at least at this point. So here we are just a few days before trial, and we don't know with any certainty whether the state will be moving forward with the third-degree murder charge. What we do know is second-degree manslaughter and second-degree murder are both the charges they are for sure pursuing. As to the other officers, I'll just speak to them really briefly. They are also charged with second-degree murder and second-degree manslaughter, but under a theory of accomplice liability, meaning that they helped Chauvin, that they did not personally murder Mr. Floyd, but that they assisted in the murder. The state is trying to also file third-degree murder charges against them, but none of that's going to be decided, and their trials aren't starting until August, so not as much of a concern yet as to how that will play out in those cases.
Thank you, Professor Moran, for that very clear explanation. I don't think I've seen it any place so clearly explained, so thank you. Professor Paulus, you bring a wealth of experience like everyone else to this panel, but I want to ask you to perhaps break down and do some trial foreshadowing for us. What will be the government's theory of this case, and what will be the defense's theory of the case as we watch this unfold in the next couple of weeks? Oh, you're muted, Professor.
Thank you. Thank you, Dr. Williams. I want to start by just saying this is an emotionally unsettling case for me personally. I cannot imagine what the Floyd family is going through right now, and I wish to express my deepest sympathy for their loss. I do think it is important for lawyers to speak clearly because we work in a profession where words matter. And so I am going to be speaking very clearly about what both the government and the defense have signaled about their theories of the case in response to your question, Dr. Williams. And at times where I think it's appropriate, I will quote from documents that some people might react to, but these descriptions are very explicit and they're very straightforward about the various theories that are being proposed. Really, this case comes down to cause of death. And no one disputes that Mr. Floyd was killed while in police custody. The question is, how is he killed? The government's theory of the case, in a phrase, is excessive force. So the government is going to argue that Derek Chauvin and his former colleagues, all fired from the Minneapolis Police Department, used inappropriate levels of force. By contrast, the defense is claiming that all the police, particularly Derek Chauvin, used reasonable force, and they are also going to claim that Mr. Floyd is to blame for his own death. So let me just walk through what the pretrial filings and public statements of both sides have already indicated. So first of all, the government has alleged that Derek Chauvin in particular had a modus operandi, meaning a practice of using holds on suspects and using excessive force. And they point out that he's essentially a bad apple who's faced 17 complaints over the years, including 3 shootings and 1 fatal shooting. The government also, I think, will walk very slowly and methodically through the timeline of what happened here. For anyone who's watched the painful video of what happened to Mr. Floyd, what was done to him, the government will walk through that minute by minute, second by second. They will point out that Mr. Floyd was handcuffed. He carried no weapons. He was speaking politely to the officers. He never at any point raised his voice, used profanity, or made any threats. By contrast, the police raised their voice, threatened weapons, used profanity, and threatened onlookers. The government will also point out that Mr. Floyd was initially very calm, while the police were, in their view, out of control from the outset. And they themselves initially described the scene as being under control. The government's theory of the case is also that Mr. Floyd became upset because he had just lost his mother, he had been shot by the police in the past, he had some claustrophobia, and he became very anxious as the police escalated their behavior. The government will claim that Chauvin in particular knew that Mr. Floyd was having trouble breathing, that he told officers he just had COVID, and that he said he could not breathe repeatedly. In total lack of deference to anything Mr. Floyd said, the police hogtied him at one point. They used a variation of what's called maximal restraint technique to secure every part of his body. And at one point, when concerned onlookers expressed fear for Mr. Floyd's life, Derek Chauvin threatened to mace an off-duty firefighter who simply asked that he take Mr. Floyd's pulse. He also threatened other onlookers with mace, and one of his colleagues ordered onlookers to stop filming to move to a different location where the scene unfolding was not evident to onlookers. I think one critical piece of the government's theory is that Derek Chauvin continued to kneel on Mr. Floyd's neck even after Mr. Floyd stopped breathing, even after his colleague Kyung confirmed that Mr. Floyd had no pulse, and even after medical personnel arrived on the scene to treat Mr. Floyd. In fact, you can see from the video that one of the emergency personnel basically gestures and tries to physically move Derek Chauvin off Mr. Floyd's non-responsive body. So in a quote from the government papers, they say, for nearly 9 minutes, Chauvin knelt on Floyd's neck, Kyung and Lane remained atop Floyd's back and legs, and Tao continued to prevent the crowd of concerned citizens from interceding. The government also argues that we can understand Derek Chauvin's intent by the way he reacted to Mr. Floyd and the way he spoke to him. So as Mr. Floyd called for help, begged for relief, even called out for his recently deceased mother, Derek Chauvin simply responded sarcastically, "Yeah, but you're doing a lot of talking though." That's a direct quote. So in essence, the government is claiming that the cause of death here was suffocation through a combination of the restraints resulting in a heart attack. With regard to the other 3 officers, the government is claiming that they did not intervene, despite the fact that they also had signals of Mr. Floyd's medical distress, his absence of any threat to the officers or any onlooker, and the pleas of the crowd that had gathered. In addition, although this is unlikely to come out in the main trial, it will likely come out at sentencing if any defendants are convicted. The government is also claiming that these defendants committed the actions, all 4 of them, in the face of what the law calls aggravating factors. In other words, factors that increase the level of cruelty and therefore make them worthy of a sentencing enhancement. And so the government claims this crime was committed in concert, in the presence of children, while on duty, through an abuse of official power, i.e. because they were wearing their uniforms and their badges. After Mr. Floyd was already vulnerable, handcuffed behind his back, knowing that he had an inability to breathe, knowing that at some point he lost consciousness, knowing that his heart had stopped, and in total disregard for life and health, ignoring the pleas of onlookers for help, ignoring the statements of medical personnel that he had stopped breathing, ignoring the requests for medical intervention. One thing that is lacking that people may be surprised by is that the state at this point is not directly alleging that race was a motivating factor in this treatment, at least not in the pleadings that they filed thus far. Now, by contrast, the defense's theory of the case really pulls out the same sort of theory that accused police officers have used historically in trials, which I would call the blame the victim card. This also relies heavily on racial stereotypes that have been successful in past trials around the country. So Derek Chauvin and his co-defendants are claiming that they all used reasonable force. And they point to multiple factors, asserting that Mr. Floyd is to blame for his own death. In Derek Chauvin's court pleadings, he claims that the most likely cause of Mr. Floyd's death was a fentanyl or combination of drug overdose with his underlying health conditions. That's a direct quote from their pleadings. They also claim that Mr. Floyd had other medical conditions that led to his death, in addition to heart disease, oversized lungs, sickle cell anemia, and a recent COVID diagnosis. The defense claims that the reason Mr. Floyd could not breathe was not because Derek Chauvin was kneeling on his neck for almost 9 minutes, but because Mr. Floyd had drugs in his system. And they point to fentanyl, possibly a speedball, and other drugs that they allege he was using. They also claim that Mr. Floyd was a longtime drug addict, and in particular, addicted to opioids. Their theory of how this crime or how this event unfolded was that Mr. Floyd and his Confederates were trying to conceal drugs, and that was the reason for their anxiety and their lack of compliance with police. They also claimed that he, Mr. Floyd in particular, had a practice of trying to hide narcotics when approached by police, that his fear wasn't based on his interactions with police, but his own alleged criminal conduct. They also claimed that Mr. Floyd had a criminal record, had a record of consorting with other criminals, and that essentially he was a large, unruly man who was struggling against police. They point out multiple times his size, the fact that he was about 6'4" and weighed over 200 pounds, and that he was resisting the police's lawful directions. And the government's response to all this is that although the autopsy showed that there was some level of narcotics in Mr. Floyd's system, that in no way was the predominating factor or reason for his death, and that the drugs plus the underlying health condition could not be the sole cause of Mr. Floyd's death, and that the prominent cause of Mr. Floyd's death was Derek Chauvin cutting off his air supply by kneeling on his neck. So that is what this case comes down to in terms of contrasting the different theories of how police can use force against suspects.
Thank you, Professor Paulus, and thank you for the broader context with regard to the historic nature of those arguments. That is, I think, very helpful and will be very helpful for those who are in attendance today. The next question, and we're going to begin to take questions from the audience after this next question. So if you have those questions, please feel free to put them in the chat. I know that Professor Osler has answered a few of those already, but certainly queue those up at this point. Professor Osler, you mentioned in the beginning, you have a piece coming out in CNN tomorrow that warns that we should not anticipate that this case will turn on issues of race, and that we should be thinking very clearly about decoupling those as we think about this trial. Despite that, there's certainly going to be significance for this case in terms of conversations around racial justice, conversations about police brutality reform, and systemic bias. I would like all three of you to weigh in on the implications for this case in that arena, both legally, not solely in terms of this case, but in terms of conversations about the legal system, and in any other way that you think is appropriate as we help this audience kind of unpack this. And I'd like to begin, if you don't mind, with you, Professor Moran.
Sure, thank you, Dr. Williams. In one sense, this case is incredibly significant for our country's reckoning with issues of racial injustice. I'm a defense attorney. I don't necessarily always put a lot of hope or faith in the ability of criminal prosecutions to remedy things. But one of the tragedies that is at the forefront, perhaps not of the conversation and trial, but of most people's minds, is this case is emblematic of a long history of Black people being killed at the hands of white people, and white people having legal impunity for those actions. A couple years ago, I went down to the Equal Justice Initiative's memorial around that memorial is specifically centered around lynchings, and it's impossible to decouple this case from the history of racial injustice in our country, and specifically of violence toward Black people, and not being white people getting away with that. And so in one sense, I think for many people, this trial is a cry for some level of justice, for someone to be held accountable for that kind of a killing. On the other sense, though, I do think we have to be realistic about the shortcomings of criminal trials. They don't bring back Mr. Floyd. They don't necessarily bring much measure of peace to his grieving family. One of our former colleagues at the law school, Nikema Levy-Armstrong, published a piece either yesterday or the day before called "Will There Be Justice for George Floyd?" And she speaks to that issue from the perspective of a longtime Black Minneapolis resident of, can this trial really accomplish much for Mr. Floyd or for the broader issues that that this trial brings up? So I think I would say, yes, it's incredibly significant. On the other hand, it's almost inevitably unsatisfying. We have bigger things that we need to deal with. We have both the Twin Cities and the country have much broader issues to grapple with. I do want to point out that since George Floyd's death, there have been at least 25 states that have passed reforms around policing, measures to reform or policing or hold police officers more accountable. The KSTP did a feature last night called Justifying the Force, which investigates Minneapolis's own history of improperly or inadequately disciplining officers for misconduct. So this is at least some of the issues, some of the racial issues and some of the reform issues are becoming much more of a conversation because of this tragedy. But I think that the criminal prosecution can only do so much.
Thank you, Professor Moran. Same question for you. By the way, to the audience, Professor Moran was actually featured in that piece. We're going to be putting a link to that in the chat. Same question for you, Professor Osler. What do you think about the implications of this with regard to the issues that we talked about in the question?
Yeah, well, as usual, Professor Moran is exactly right. She was a defense attorney. Professor Paulus and I were both federal prosecutors. So even coming from different sides, I think we see the same thing here. And one thing is, again, once you get into the courtroom, it's about elements. And it's telling that we don't have a bias crime that would apply here. That in Minnesota, we limit our consideration of bias in crimes to 4th degree assault. Things elevate from 5th degree assault to 4th degree assault. And that's typical across the country. You look at the death penalty statute in Texas. There's all kinds of things that can elevate something to a death penalty case. If you kill a fireman, more than 2 people will die. It's a child under 15 if it's in the course of a robbery, but not if it's a hate crime. And so we don't have bias considered very often because it's not an element. Now, going back to what Professor Moran said, yes, the danger here is that this trial has a huge potential to make the racial divide and tension in this country worse, but not a lot of potential to make it better. There's a couple of things. I mean, of course, if the outcome is an acquittal, that'll reify the belief many people have, beliefs which are largely justified, that white people get away with it, especially white police officers get away with it. But even short of that, in the course of the trial itself, just the nature of these things is going to exacerbate racial tensions. Inside the courthouse, we are going to have, as Professor Paulus put it, we're going to have blaming of the victim. There's going to be a lot of focus, if they can get it in, on drug use, for example, by George Floyd. And to the people on the outside who are viewing this as a racial issue, they're going to say that they're taking the Black victim and tearing him down in a fairly stereotypical way. And that critique will be correct. And so there's great danger there. I mean, that in the end, I completely agree with Professor Moran that we criminal trial lawyers are a lousy way to heal things, that we have to do that hard work outside of the courts. And there's a lot of that work to do. Now, some of it's in legislatures, as Professor Moran said, in making the law different. But a lot of it is also in how we view the rest of our world and how we relate to one another and what we're willing to condemn and accept. That George Floyd isn't going to save us, and the trial isn't going to save us. We need to address our issues directly in a broader way.
Thank you, Dr. Osler. In fact, we're going to come back to that. That's actually our last question, because there are a lot of people who are wondering in this moment what they can do. But I want to ask you the same question, Dr. Paulus, particularly because you wrote about this in the Washington Post not too long ago, and we're kind of projecting what you thought some of the issues around how we need to view this in the context of these larger discussions are. So if you could share your perspective, I'd appreciate it.
Sure. I mean, I think one of the critical issues here is African Americans and Anglos view the police very differently, and their experience with the police is very different. There is no other profession in this country where we allow people to kill other people because of their fear. And the concern is, are the police treating African Americans as if they are occupied people in a war zone? And so these are the questions that I ask. Would this crime even have happened if Mr. Floyd were a middle-aged white man wearing a suit, driving a BMW? Would Cup Foods even have called the police to assume that he was a criminal as opposed to mistakenly using a bad bill? Would the police have felt the need to apprehend the suspect with weapons drawn, screaming profanities, and binding him without even hearing his side of the story? Never once did they ask him what happened. Would the police have felt it was appropriate to use lethal force in a crime alleging the use of a $20 counterfeit bill, a very low-level, non-violent offense wherein an unarmed suspect was not fleeing? And so these tropes that the defense has dragged out, I think a real question in this trial is going to be, will they be successful? Or have we as a country finally come to a point where we realize there is no justification for this behavior? It reminds me very much, because we think in Minnesota that we're progressive. We're not, as to people of color. And the things that defense lawyers have said and that juries have accepted are sometimes outrageous. And I say this as someone who is currently a defense attorney, and mindful of my need to aggressively pursue every viable line of defense for my client, but to do so in a respectful way and in a truthful way. And so this reminds me of what happened very recently in the trial of Geronimo Llanas, the officer who killed Philando Castile. And his lawyer literally said in a court pleading that Mr. Castile was, quote, asking to be shot. No African American is asking to be shot. No woman is asking to be raped. No child is asking to be abused. And I think we have to come to a point in this country where we say that is not the type of language that we use in a civilized society. And those justifications are not going to be a winning argument anymore in any American courtroom.
Thank you, Professor Paulus. When you talk about the echoes of the past with regard to this case, I think the history is powerful. My colleague, Michael Lansing at Augsburg, has written a piece on policing in the 1960s, which very much echoes today. My work is on the 1970s and the Minneapolis police and the terrible summer of 1975, where you have Arthur Cunningham, the president of the NAACP here in Minneapolis, saying that the police have declared war on Blacks and Indians. In the aftermath of a shooting of a 14-year-old boy that summer, that resulted in a Minnesota Human Rights Commission investigation, 3 days of public hearings, and then ultimately no action and very little reform. So when you talk about that long history, I think it's powerful and leads us to interrogate exactly what the three of you have raised this afternoon, and that is, what changes can we expect? But then I think we go back to your point, Professor Osler, what is our responsibility? Which brings us to this final question before I turn to the questions that are coming in from the audience, which are great. And that is this: how can the UST community, how can those people who are in our hearing this afternoon, whether they be part of the YWCA, McAllister, Augsburg, any of the other guests who've joined us, how can they begin to prepare not only for the trial, but to start to pivot and think about how we support the community, how we are of the community in this moment? And I'll actually begin in reverse order. So if you don't mind, Professor Paulus, I'll ask you to go first.
Well, I think that the most important thing here is the ability of the people to hold their government accountable. And whether it's through the jury trial system, which in this case is critically important because the person on trial is an officer of the government, or through voting, or through running for office, or through peacefully demonstrating that this not be a passing fad, but a permanent commitment to change. We've asked for a long time for patience from people of color, and we've asked for them to excuse slavery and disenfranchisement and police brutality because of white fear, white inconvenience, white irrational fear. It's time for us to stop asking anything of African Americans. It's time for us to listen, to change, and to do it now.
Thank you. Same question, Dr. Osler.
Yeah, I mean, boy, supporting communities is going to depend on what your community is. I think a companion question to that is, how are we going to challenge our communities? That, you know, in the communities that I walk in, I think the bigger challenge is to challenge them to engage with this trial, to engage with the death and the commonality of the violence that we see exposed here. And maybe the best thing that I can do for the larger community is to challenge some of the people that I see who don't see it, who don't get it, who would rather not look that way.
Fantastic. Thank you. And Dr. Moran.
I'm going to pose an encouragement for the exercise of empathy. And I've been thinking about, a lot of people have fears about this trial about to start, and what will happen to the city? What will, will it be like last summer? Or, and I want to specifically ask people to interrogate those fears a little bit, because some of us have we're worried about different things, and that is, I've heard a lot of white people say that they are worried about the city getting, property damage again, or the city getting disrupted or going up in flames. And I don't mean to invalidate that at all. I've experienced those concerns too. What is downtown going to look like? Are we going to go through the trauma of last summer in that sense? But I know people who their fear is, what if this man gets acquitted and it again feels like my life doesn't matter? And that's a different fear. And so I especially want to just encourage my white friends and family and colleagues, think about, if you're feeling anxiety or uncertainty about this trial, what is that rooted in what might other people be feeling in terms of anxiety or uncertainty or fear or trauma around this situation? Because we're not all afraid of the same thing. And then the last thing I would say is, there are some folks with deep roots in the community who have been, who would be worth elevating in this situation. So I'll point to two in particular. There's an organization called Families Supporting Families Against Police Violence here in the Twin Cities, that you could Google that, look up their website, or maybe we can get you a link, but they're an organization that is comprised primarily of people who have actually experienced police violence, or families who have suffered the loss of loved ones. And then there are the demands of the people who have been holding space at George Floyd Square, the site of his death, the memorial surrounding it. And they have identified a number of action items that they are requesting of the city to create a more just society. And so that would be worth looking into as well, if you're wondering, what are some, how can I inform myself about the suffering others have experienced? Those are two places I would point to.
Fantastic. Thank you, Professor Moran. I'm going to move now to the questions we have from the audience, and I'm going to apologize in advance for my colleague, Professor Osler, who has to leave a little early today. So I'll try to get his answers to these questions first. But the first question is from Faith Paul, who asks, apologies if this has already been addressed. If there is an acquittal in the first trial, what are the implications for the second?
Well, I'll go first. It doesn't mean that there won't be a second trial. But one thing to keep in mind too is that if there's an acquittal in the first trial, there's definitely the possibility that the U.S. attorney will take up the case as a civil rights violation. We saw that, for example, in the Rodney King case, that the police there were acquitted after everything was on video. They took him up on federal charges and he was convicted there. So don't think it's over if there's an acquittal. But certainly if he is acquitted, that's something that potential jurors for the second trial are going to know. And that's definitely going to poison the well, even if the trial goes ahead.
Thank you. Professor Moran, Professor Paulus, anything you want to add to that? We'll move to our next one then. Marguerite Durkheim asks, Muhammad Noor was convicted. What are the differences between that case and this one that could potentially result in a different verdict?
Well, Mohammed Noor was of African descent and his victim was Anglo. And so it was one of the few times where a uniformed officer was actually found guilty of anything. And the charge that Professor Moran described so clearly earlier was third-degree murder. And that case is currently on appeal, but the most obvious difference was the race of the perpetrator and the race of the victim. And we know based on statistics from the Justice Department that the race of the victim is a significant factor in whether verdict is returned as an acquittal or a guilty verdict.
Great. Anyone else want to weigh in on that? Thank you, Dr. Paulus. This is a question from Elias Wurs. Do you believe that the recent George Floyd Justice and Policing Act will have any effect on this trial?
I can speak to that briefly, and then Professor Osler, if you want to weigh in. I think what we're referring to probably is the federal act that the House recently passed as of yesterday. So it is not an act that has yet gone into law. It would need to pass the Senate and be signed off by the president. So I don't necessarily think that will have an impact on the trial, perhaps on public perception around the need for reform. But I don't personally see that having a meaningful impact on the trial itself here. I don't know if Professor Osler feels differently.
Yeah, I agree. I mean, I really hope that it passes through the Senate and is signed by the president. So we'll see about that. But no, I mean, nothing about that is conceivably going to impact this in a direct way.
So we have a great question here from Spencer Lavelle, who's asking about the jury pool. He wants to know, they want to know, with criminal cases that everyone seems to have an opinion on, how do we choose jurors without ensuring bias is included in our decision? How do we get a seat of fair jury in this case? I'm going to interpret that as.
Well, it is difficult. You know, I mean, this is a huge challenge. There's a reason they're taking 3 weeks for jury selection, is because this is a particularly challenging case. The first question in the jury questionnaire, which is fascinating, it's publicly available, is basically tell us everything you know about this case. And I'd imagine for people that goes on, there's attachments and pages in their response. And so what they're looking for can't be someone who's never heard of George Floyd, but rather there's going to be a series of questions that will end with, when you receive these instructions, will you be able to be fair? And most people will say yes to that. Now, is it true? Sometimes not. And so that's one of the dangers of the trial.
Professor Paulus, you wanted to respond to that as well.
I was, in the law, I think we have often confused knowledge with bias. And so we've used awareness of a trial, awareness of the facts of a trial as a proxy for saying that somebody cannot view the evidence impartially. I'm not sure that that's a legitimate standard in this day and age of mass communication, particularly where the central piece of evidence is a tape, the authenticity of which no one disputes. And so the fact that people have seen that tape and seen Mr. Floyd's dying moments should not be confused with a very separate and fair question of, can a person put aside any preconceptions about any of the parties in this case and still render a fair verdict? It is interesting to me that the defendants were desperate to move venue out of the Twin Cities, which is the only segment of our state that is in any way diverse. And of the areas that they named as better jurisdictions in which to try Derek Chauvin, all of them were populations at the outer ridges of Minnesota, in rural areas that had less than 5% minority population, actually in at least 2 instances had less than 1% minority population. And so the question of this fear of being judged by a diverse pool that actually has authority over the Minneapolis Police Department was quite interesting to me, because for so many decades, again, to put this in historical context, African Americans, women, people of color were excluded from juries. And now that women plus minorities could equal a majority on a jury? What is this sudden rush to move venue and to take that power away from people who've waited a long time to even have the right to hold authority?
Professor Moran, anything to add to that?
I'll just add a little piece for those who maybe don't know how jury selection works at all, which is sometimes a better way to think of it as jury exclusion. It's not as if one side gets to pick their favorite 6 jurors and the other side gets to pick their favorite 6. It's actually just it's a random selection of people to start with, and all you get to do is kick people out. The lawyers have a limited number of people they can exclude for no articulable reason. And then they can also, there's an unlimited number of people who can be excluded based on what Professor Paulus was talking about, which is the idea that they simply cannot be fair for some reason. But I just wanted to clarify, some folks think you get to actually pick the jurors you want. It's really more of a matter of weeding out the jurors that you definitely don't want.
And just, I want to follow up. I'm going to have to pop out and head out to class, but I do want to follow up on one thing that we have as an endemic problem in the United States is a lack of minority representation on juries. I was a federal prosecutor in Detroit, and I walked into a courtroom in a major case, and out of 60 people in our panel, we had 3 African Americans. The defense attorney challenged the selection system. And when we found out from the clerk's office how we did it, they were actually, to try to even the pool, deselecting 1 out of every 5 white jurors who had returned a questionnaire. And so it still wasn't addressing the problem. So in terms of having representative juries, that's something we have a real problem with. And I wouldn't be surprised if one of the things that comes up in this jury selection is people are going to be surprised by how tilted the pool is towards white jurors.
No, I really appreciate you mentioning that, Professor Osler, because I think part of the challenge here too, when we think about this broadly in terms of the history of exclusion in this country, is how that at one point, and still in many cases, is tied to voting. When your pool of jurors is selected from your eligible pool of voters, it's often pretty clear evidence that you don't have a large number of African Americans or communities of color who are voting if they're not showing up or underrepresented in the jury pool. It was the focus of several, as all of you know, very important historic Supreme Court cases, Neal versus Delaware, certainly the Scottsboro cases. So it's important for people to understand that that's how those 6 degrees of segregation work. And if you're looking at inequality in one area, it probably is manifesting itself or germinating in other areas. We have a great question here from Professor Mike Klein, who is our Justice and Peace Studies faculty. And the question is, what is the rationale for the lag between the first and second trials? Oh, and before you answer that, Professor Osler, I know you're going to be signing off in a second. Where can people follow you on social media? If people want to follow your commentary, or can you just give us or put in the chat your Twitter or
yeah,
link?
sure. On Twitter, I am at Osler Guy, OSLERGUI. Easy to remember. If anyone wants to drop me a line via email, I'm easy to find on the St. Thomas webpage.
Great. And the question, anyone? What's the rationale for the lag between the first and second trials?
Yeah, I can take that. Originally, the defense attorneys the defendants all moved to sever the trials because their claim was that they couldn't have fair trials if they were tried together. And the Judge Cahill denied that back in the fall. He said, nope, we're going to have one joint trial. In January, he's the one who independently chose to sever the trials. And he did that purely, the only reason he gave was public health reasons. He said, it's not possible to have a safe trial with this many people and this many lawyers present in one physical space during the pandemic. So he said, we're going to move forward with Derek Chauvin's trial, and we're going to try everyone else later in August when we are very hopeful that the pandemic that will be in a safer place of the pandemic. So that's actually the only express reason given. It has nothing to do with the merits of the case, although that was something all the sides were fighting about. That's actually not the reason they were severed. They were severed purely because of the COVID crisis. And that's also why there's such a significant lag, is because Judge Cahill said, I anticipate a three defendant trial being more doable late in the summer.
Thank you. Anything to add to that, Professor Paulus?
I would just add quickly that the effect of severance will be a shift in trial strategy. So it's very clear from the filings and the public statements of defense lawyers back in the fall that Derek Chauvin viewed his interests as being very different than his three co-defendants. And essentially, you can see from his pleadings that he tries to push whatever blame he thinks should be apportioned to the police to the other three, saying they should have known about medical conditions, they should have alerted him about Mr. Floyd's distress, and that they should have worked more closely with him. Well, that has now shifted because Chauvin is being tried by himself. And if he is acquitted of any or all charges, the likelihood that the other three who are tried later in the summer are also acquitted increases dramatically. So it is now in their self-interest to work with Derek Chauvin's attorney and put forward a united front. We talk about the strong blue line, and we're going to see that resuscitated because all of their interests are now aligned given the severance of the trial, ironically.
Thank you, Professor Paulus. And we have about 4 minutes left. I want to ask both of you. I'm a big fan of your writing, Dr. Paulus, and Dr. Moran. Your Professor Moran. Yesterday, you were phenomenal on KSTP, and I enjoy watching your commentary as well. Where can people follow you on social media if they want to keep up to date with what's happening with regard to this trial and get some expert insight on what's happening?
I can post my Twitter handle in the chat as well, if that would be easiest. It's just at Rachel Moran 82.
And Dr. Paulus?
I'm afraid I'm not as sophisticated as Professor Moran or Professor Osler, so I'll try to get on that. I'm not sort of regularly updating my media coverage, but the university does send out a weekly update of all of us who are trying to help educate the community and do our civic duty by sharing what we know with the media.
Appreciate that. I'm sorry, go ahead.
No, I'm sorry.
And just to mention very quickly, we have posted in the chat that the St. Thomas libraries are compiling a list that they'll be sharing and updating daily, which you can access at the link that is there. The last question for both of you, and again, thank you for your participation today. This has been enlightening on so many different levels, and we're certainly seeing that in comments in the chat. But that this is a trial in which we've talked about the influence of technology, cameras in the court, but this is also a trial that's taking place in the context of COVID-19. You've both already alluded to this, but in what ways will the pandemic and technology influence just the trial, the proceedings themselves? I do think you've both spoken to this, but at the same time, I think it's a good question. It's probably a great place for us to end. So whoever would like to go first.
Well, I will agree strongly with Professor Paulus's comment about how it has already impacted the strategy. I think there's actually a significant benefit to the four former officers. Judge Cahill's decision to sever the trials allows them to hope for and even perhaps assist in the Chauvin defense with the idea. I'm sure they are thinking that if Mr. Chauvin is acquitted, that fares better for them. It also just allows them to hear from the witnesses. They will, of course, those lawyers will be watching the trial carefully, and it gives them more of a chance to prepare. So it has had a significant impact, I think, on strategy for the trials already. And the only other thing I'll say is, I've seen what the courtroom looks like. I've seen how they have it set up. And I think in a way it's going to be an ongoing stark daily reminder of how just how stark this situation is, the significance of the trial, the oddity of the moment, a reminder of the year we've been through, the summer we've been through in the Twin Cities. I don't think you can look, the public seating is removed, there's plexiglass everywhere, people will be wearing masks. I just don't think, even though that has nothing necessarily to do with the merits of the trial, it's just a constant reminder of the significance of the moment we're living through.
Thank you. Dr. Paulus?
It's an interesting question. I think there are going to be at least 3 impacts that we see on the trial. The first is that the judge has limited the number of people who can be in the courtroom. And so in terms of the numbers of Mr. Floyd's family who are permitted to attend, it's only 1 person at a time. which is very different than what we'd see in a typical trial. Trial teams are limited. So the state has a very large team of prosecutors, but only 4 of them, including staff assistants, will be allowed in the courtroom at a time. That's going to just impact their efficiency and I think ability to do their jobs as effectively as they would otherwise. Likewise, the defense team will be similarly limited. Secondly, so much of communication is in our faces, and with half a face masked, people are not going to be able to read human emotion and reaction and calibrate argument, calibrate strategy, calibrate reaction in the same way that we could if we weren't wearing masks on our face. I think the third thing is clearly this has inspired a global movement and daily crowds of protesters. But given the limits on protesting, I think this will have the effect of severely curtailing the First Amendment abilities of crowds to gather, given population control and edicts set out by the governor in the state regarding mass gatherings. And so you're not going to see the same sort of public reaction that I think could be possible otherwise.
Thank you, Dr. Paulus, and thank you, Dr. Moran. You know, we held this forum because knowledge is power, and ultimately we want to empower people to know more about what's happening in this upcoming trial, these upcoming proceedings. At the same time, knowledge devoid of human empathy is empty. And so we can't lose sight of our shared humanity in our present context. If you're thinking about trying to find a way to take action, empower yourself first by following what's happening, but also thinking broadly in the way that all of our panelists have suggested this afternoon about the larger work, the greater work to be done. And that's dismantling all forms of inequality in the communities in which we inhabit together. Thank you for joining us today. Thank you again, Professor Moran and Professor Paulus and Professor Osler, and we'll see you again next time. Everybody be safe.